Good evening, everybody. I'm Ella van Kranenburg. Obviously, I'm not Peter. I think that can be seen. Peter's my colleague. I'm a lawyer. Peter is to become a lawyer somewhere, I think, in 2021. This works better. And Peter has a PhD on outsourcing, which is a very specific area. You cannot hear me?
No. The microphone.
Sorry, I need to speak in the mic? Okay, sorry. Excuse me. So I'm Ella van Kranenburg, I'm a lawyer. Peter's my colleague. Peter holds a PhD on outsourcing with respect to financial services. So financial parties operating in the financial services industry can outsource part of the activities, and that's a regulated activity for the purposes of regulators. Now I can hear speaking in the mic. Actually, I was here about, I think, 3 years ago. Also obviously on legal topics, and there was no regulation at all regarding bitcoins or virtual currencies. And then I said, well, what we can see now from what's happening in Europe, and that was after Paris attacks, I think that the first regulation where we will find the virtual currency being regulated is anti-money laundering, and indeed that has happened. So we have now within the anti-money laundering, I hear a lot of what is that? Echo. Is that right?
Yes.
Yeah. I'm not sure what's happening. Is that the mic or?
It's that one.
Oh. So you killed the mic. Better? Sorry. Not sure. You shouldn't move, I think. So we have an anti-money laundering regulation, which actually applies already to a lot of entities in the financial services, but it also applies, for example, to me as a lawyer or to notaries, which actually effectively means that before entering into a relationship with a customer or client, you need to identify your client. What is new and what the reason we're here is, as I said, we now have the anti-money laundering directive being applied to parties who are operating in the sphere of virtual currencies, which is specifically the exchange service providers and the custodian wallet providers. As said, this was introduced because, or as a result of the Paris attacks, because people think that virtual currencies are very scary and that they're operating in a domain which is sketchy and cannot be seen. It's unclear who owns them, or people are uncertain who owns them. So regulators think that by introducing these rules, they will have more sight on what's happening in the crypto sphere in terms of who owns or who owns currencies. So this is actually the place in legislation where we now, from a European perspective, have introduced regulation for for virtual currency wallet providers and exchange service providers. I need to go back to this one because this is actually what it's about. This is not very. So it's about these parties are becoming registered. Are you sure this is better? Because are you sure that you cannot hear me if I speak out loud? Because this is really horrible. Okay. Wow, that's better. Good. Feeling much more. Okay, so wallet providers and exchange services providers have become subject, or will become subject as of the beginning of next year, on a registration regime. So this is throughout the whole of Europe because it is a European directive. So one of the additional aspects that will be checked in part of the registration is that the people who are sort of the management functions of these entities are to be fit and proper. This is a requirement that will be imposed as terms of the registration. I guess what's important, of course, is when looking at regulation, we are used to looking at terminology because you need to know which parties are actually covered by this term custodian wallet provider an exchange service provider. Effectively, there's no real definition of exchange service provider, but the directive does give a definition for these custodian wallet providers. So that's where we should look at whether or not parties will actually be subjected to this registration. To understand the background, so we have a European directive, and the system in Europe works as such that directives need to be implemented in local law. So we have a European directive for anti-money laundering, which was already in place in the Netherlands, in the Dutch Anti-Money Laundering Act, and the act is being replaced or being renewed by introducing AML 4 and 5, which includes these rules for registration. When the laws are not introduced just by people sitting somewhere, unfortunately, or maybe fortunately, I think it's a democratic system, at least we hope it is. And what happens is that when a directive is implemented in the Netherlands, you see introductory law developing. So the government will, or the ministry, the relevant ministry will say, I'm introducing a new law, this is how it will look like. And what we then saw in the Netherlands, which was quite exceptional, was that the registration regime suddenly was introduced as a license regime, which is completely different because the registration is like, here, you find the form, I'm registered, whereas the license is, can I please get a license, and what do I need to do to get a license? So there was a lot of debate, the State Council was against it, and then what happened, we saw the draft legislation being changed, and still, it was a license in disguise, because if you really look at the registration regime, it actually means that the relevant regulator, which will look at the registration, which is the Dutch Central Bank, will not give you the registration if you don't go through certain hurdles, which are quite similar or have similarities to a license requirement. So I think it's important. Sure, no, go ahead.
So that's 6 weeks from now?
Yes.
What happens if, and they have to do the background checks on, as you say, all the people involved there as well?
Yes.
So what happens if you're not registered by the 10th of January?
Then this could happen to you. Because effectively you need the registration in order to be a custodian wallet provider or to have an exchange service. Yes, you have a question?
How is it democratical if you did like, this is decided by the major community?
No, this is decided by government. So we choose government.
Then how is it democratical?
Because we chose our government. That's how our democracy works.
Very well, yeah.
And they make the laws.
Makes sense in the sense of innovation.
I know, but it is how our law or how our state is organized, that we choose our government. And
our government is organized, I understand very well. But yeah.
Yes, but I think that the reality for sorry?
If you go into the fundamentals of democracy, it's not democratic.
We can have
a large debate about this.
About constitutional law.
Yeah, okay.
I love it, but I think most of us are going to get bored when it comes to constitutional law.
Well, I'm not bored by it.
Well, you're not, but I'm going to have a discussion with you afterwards. So.
So what happens? And to get back to your question, I think about 2-3 weeks ago I was at an event organized by DNB, the Dutch Central Bank, because they said all these wallet providers, custodian wallet providers and exchanges, they are new to us. We're not aware they are to become our friends, they were basically said. So please come and we'll tell you about this registration and we'll explain. And there was a big group. So relatively a lot of the people or the parties out there that are providing these services are aware of these rules and are getting prepared for them. So that is what's happening, but we're not sure if everybody's covered. But if you're not covered, if you're not registered, or you're not following up on what comes from this registration, and that's what Peter will talk about, or at least the AML requirements, then you run the risk that you're actually breaching the relevant law that's applicable to you, and that's the Dutch AML Act. So de wet ter voorkoming witwassen terrorisme financiering. And that effectively means it's administrative law, and this is not specific to virtual currency or whatever. This is just administrative law being not being adhered to. It can result in criminal action. Actually, that's what happened to ING. So ING breached AML regulation, they were they were followed by DNB. DNB said, I think the Dutch prosecutor needs to prosecute. So there actually was a criminal proceeding against the bank because of not following up on money laundering regulation. And as you can see from the below, there's a big risk certainly for also bigger institutions that if you get a fine, it's incredibly high because it should be the higher of either 5 million or 10% of your turnover at group level, by the way.
I'm sorry, but is it only applicable to the wallet providers where the conversion happens from fiat to cryptocurrency, or is it applicable to the whole market?
Effectively, it should be applicable to the whole market.
But in practice?
Well, there you should go back to this. That's why I said definition is always relevant to put it in scope. So it says an entity that provides service to safeguard private cryptographic keys on behalf of customer to hold, store, and transfer virtual currency. So that, I guess that, yeah.
I have a question regarding that. Does that also involve if you are one part of a multi-signature?
Whoa.
In the break.
I mean, it's okay to say that you don't know. I'm just wondering.
I think that is a question that we should defer to the regulator and see what they think.
I'm sure they'll know exactly.
I would need some explanation up to this point.
So going back, and I'm trying to run through this because actually Peter is the one that's doing the part on the outsourcing, which we were actually to talk about, but I thought we needed a bit of a background on where this comes from. So what is AML going to do? It's going to ask the exchange service providers and the custodian water providers to actually check their clients. So that means verify their clients and also to monitor transactions, and which is interesting because that means you need to constantly, somebody's laughing here, but it is what AML asks, and whether it's realistic from a perspective of virtual currency exchanges or wallet providers, that's to me unsure, but it is what the law would ask you to do. So you need to identify your client, verify that it's indeed Peter that I have here. If it's a company, you would need to identify the beneficial owners, who is all up to the chain holding up to 25% or more. Determine the representative, if the people coming to you is actually authorized to represent the company that it says it's representing. If it's a politically exposed person, that means you actually need to increase the scrutiny on your check. That means your customer is increased as an integrity risk. That also actually applies to the spouses of these people. So it's very broad, and it's a category which is much debated because it will move. There was a discussion, for example, do you think that the mayor of Amsterdam is a PEP?
Is it PEP?
Yes. PEP, politically exposed person. Yes or no?
Yes.
No. And there was very, very obscure foundation for literature, something which apparently was based on some kind of international treaty, which is, if you're director in that organization, you're PEP, but Femke Halsema is not a PEP. So it's very obscure. So now we move to Peter, because actually he was here to tell you a bit about outsourcing, because you can see from what's required or what will be imposed on these parties is quite severe. And there are parties out there that will tell you, it costs you money, but I can do it for you. So you can actually outsource KYC. It's done a lot. It's done a lot in the financial services industry. But here, of course, it's interesting that you're actually outsourcing the very part that made you subject to regulation in the first part. But we'll probably have some discussion on that. Have you had it? Yeah.
Yes, I have some mic too. I don't know if it's doing anything. Ella is the funny part of us. She found this Dilbert cartoon where Dilbert is coming up to his boss and he explains, I find out we've outsourced some important stuff, and to some some country, and that they subcontracted to some other shady country, and subcontracting further, and in the end, the party actually doing the stuff is probably the most shady entity because, well, they are the cheapest, good for us, but it's only because they lie about the quality they deliver. It ends up, by the way, to be themselves, so they've outsourced it to themselves. That's the joke. I like jokes. Outsourcing. The relevance is the KYC obligations are quite strict. Liability obligations can be strict. Well, okay, who cares? But the point with outsourcing in the financial industry is, whether you outsource or not, you always retain full responsibility about the outcomes, about the results. So if your service provider is screwing up, the supervisor is going to say, you screwed up. Your supervisor's fault is your fault. I'm going to hold you responsible. So that's one thing. You have a big incentive then to prevent your service provider from screwing up. Because, well, penalties, monetary damages, you may be able to recover part of it. Part of it because your service provider is probably going to have a liability limitation clause. So it's only liable to a certain amount of money, and only in some kind of cases, not always. So you might not be able to recover. And if he is held liable to you for the damages he created for you, he may not be able to pay up. So that's one problem. And even if you can recover your damages, damn, your criminal liability is for you. You cannot recover a sentence. Okay, so you might want to prevent that. Still, the problem exists and it needs to be solved. Supervisor is going to require you to solve the problem. So you need to intervene in your service provider's operations. Tell him, hey, things have to change, and in this way. Can you actually intervene in his operations? Usually, your service provider does his thing and does not want you to interfere. You don't want several other people to interfere in your business because it would be unmanageable. So it's a tricky thing. And of course, there's a reputational damage. You've been involved with some shady and criminal and terrorist things, apparently. It's going to be in the newspaper anyway. So, darn. Further, well, Ella told this already. The very reason, pretty much the only reason why these parties are going to be under these regulations is because of the KYC obligations. And if that is what you're going to outsource, supervisor coming with you, right, show me your KYC things. Oh, you've outsourced it. Oh, okay, I'm going to look at your outsourcing. So supervisor is going to pay attention. Moreover, because they don't take KYC lightly. Oh, thank you. Thank you. Usually I do my presentations all alone. This is service. Right, so you need to be have your outsourcing proper. What can you outsource? Well, basically everything. However, not to, well, at least one of the most important things, you cannot outsource the transaction monitoring, which is quite a shame. But thanks to our good government, they've realized this apparently, and they have plans to change it. So probably in the near future, well, somewhat near future, you'll be able to outsource transaction monitoring. Not for now. And you cannot outsource the ongoing monitoring of your business relationship with your customers. You have to do it yourself. Okay. That being said, you can, in essence, outsource to any other party. Okay. any other party. But, well, you don't want to be like Dilbert. The crucial thing is to select your service provider. If your service provider is rubbish, it will be rubbish. It's going to be your problem. So selection is the most important part. You have to be sure that he is capable of doing KYC properly. He has the capacity to do it properly. But at the very least. And then still you have to make some arrangements in your outsourcing contract. Well, outsourcing contract is only required if you outsource KYC on a structural basis. Whatever structural may be, because 2 times, 4 times, I don't know. But probably you're going to have a written agreement anyway, would be a smart thing. And the other thing that law says you need to arrange is that your service provider provides you, at request, immediately, the relevant copies of identification. Okay, so you'll end up agreeing that in your contract too. But it's not going to stay with that. If you leave it to that, you're going to be in problem anyway. You have to be sure, because it's your own responsibility, that your service provider is doing the right level of scrutiny on identifying the customer. So if it's a high-risk person, he has to apply the high-risk procedures. And you have to be sure that he is going to apply the high-risk procedures. So you need a policy to prescribe to your service provider, in these cases, is the high-risk procedures. And it has to be very clear. No debate about it. And better err on the safe side. Still, you might find out about some cases where your policy says this is low risk, but when you look at the case, you think, oh, gosh, this is high risk. So you need to be able to instruct your service provider, redo this customer, redo the KYC, and now as a high risk. Learning about certain situations, you may want to change your policy. 2 minutes. Okay, you want to change your policies, and regulations will change. I promise you they will change. So you need to be able to change your policy, which your service provider is going to apply. You need to be able to check compliance of your service provider with your policies. Your supervisor is going to be very strict on that. Liability clause, they're fantastic to talk about. Your service provider will want a limited liability. You don't want. Cancellation, when can he cancel the contract? When can you cancel the contract? And this is extra important because what if your service provider ends up cancelling your contract? Or if your service provider turns out to be this kind of tech person, not living up to your expectations, or he goes bankrupt. You want to get rid of him, or he wants to get rid of you. What is your fallback option? Can you, in due time, fast enough, change to another service provider, or can you do it yourself? I have to hurry up, I notice. You have to think about that beforehand. Just in time. So, in short, well, you can read it, but I'll read it for you. These KYC obligations are going to apply to ESPs and CWPs beginning next year, all of them. You cannot outsource transaction monitoring and the ongoing monitoring of your relationship with the customer. You're probably going to need a written contract. Okay, it's not really a challenge, but still, you have to do it. It's all about business integrity. Can you prove to your supervisor we are clean. And business continuity, because if your super service provider quits, you cannot accept new clients unless you have some other person to do your KYC. DNB is going to be very strict on this, looking out for you, and well, know your service provider. Be sure he does well. Just in time? Just in time.
Thank you very much. It's obvious that you're so we ran out a little bit already.
Oh, sorry.
That's okay. Because we are missing someone. So, is there any questions, urgent questions now, or any questions that can wait until the break? Oh, there are questions. Good.
Yeah, basically what I would like to know is where the border is for who these rules apply. So, for example, this applies to exchanges, also exchanges or services that hold the private keys, for example, for cryptocurrencies. But does it also apply for people who only provide software or hardware wallets? And what, for example, in the case of Edge, where you basically have a peer-to-peer exchange, so they're not really involved themselves in the exchange. Where's the border? Who does it apply? That's basically what I want to know.
Your question? Well, in the end, it's all about interpretation of law.
And there's no definition.
Sorry.
No, but there's no definition
Yes.
of this exchange, so that's the problem. As there's no definition of the exchange, it's...
Okay, the exchange is part of the definition. You need
Yes.
to have, okay.
It's part of, it's either a custodian wallet provider where the directive gave a specific definition, or it's an exchange service provider where it's open to interpretation.
Okay, so I already know, because custodian and exchange, so
Yes.
not a service provider, but like on the software or hardware.
Probably not, no.
I wouldn't expect them. No.
Behind you, there was a question.
I was wondering, very good presentation, by the way. I was wondering about value versus risk.
Very good question already.
If you think about outsourcing and business value that possibly can generate, how do you verse the risk based on your presentation?
Mm-hmm.
Do you have any experience with that, or can you explain a little bit more?
If you have experiences with outsourcing of KYC obligations?
Or in general?
In general.
Just in general, yeah.
No. Well, outsourcing in general, I have lots of experience with it. I've spent years studying it even. So
I mean more concerned with some of the risks that
Mhm.
you pointed out and the financial consequences.
Yeah.
How do you quantify that to make a decision?
Well, risks can be quantified, theoretically. Okay, so basically the model is P times Q is R. The chance of something going wrong in a certain way times the outcome, the shit that happens when it does go wrong, is your risk. But it's a theoretical model, so you have to assign values. It's, well, but still, if you apply this model, at least you get some feel for the quantity of risk. Because if you don't, like many parties do actually, you have no idea where your risks are and what are your major risks. So trying to quantify your risks is useful anyway.
I think if I may, one of the things that's outsourcing, again, is not specific to... So in general, in the financial services sector, outsourcing happens at various levels. It could be IT, it could be anything. And usually it's a matter of either it's cost efficiency, or you have somebody who's doing it very well and has the efficiency, not only cost, but it's just better at it than you doing. For example, as an exchange service provider, you may not want to do this, but it's something that is imposed on you. And I think very interestingly, not this DNB, but the AFM, which is another regulator in the Netherlands, recently issued a paper regarding fund management. And they actually looked at whether fund managers were outsourcing parts of their business and what the risks were. And I was discussing, we like these discussions, and I said, Peter, you saw what the AFM said. They said actually that when parties do not outsource, In the future, the AFM will consider that a risk also. Okay, you can never do it right, with the regulators. So they said maybe you're too small and you have to outsource some part of your business because you're not capable of doing everything. So you may need to find somebody to do it. So again, going from risk and value, it also has a regulatory risk, and that also has value, because if a regulator says you're not doing it right and you lose the license to operate, gone is your value, I would say.
Thank you very much.
Yeah.
Thank you. And I hope you stick around for the break. So
Yes,
people
sure.
can ask some more.
Are there actually is there anybody here which is in the exchange or wallet provider? Probably not.
Exchange wallet
Yeah,
providers.
yeah,
Can you
Okay.
raise your hand?
yeah, okay.
A fair few.
Yeah.
Thank you very much once again.